2016, when Sigfredo Garcia was arrested and the probable cause affidavit for his arrest became known to the Adelsons, they all lawyered up. So did Catherine Magbanua. Investigators were puzzled because they were trying to get Magbanua to cooperate, but she wouldn't. They even met with her brother and hinted that if Katie helped in the murder case, maybe his wife, who also faced criminal charges, could get a better deal too. Still, no cooperation. Over time, suspicions grew. Prosecutors started to believe that the Adelsons' lawyers and Magbanua's lawyers might be collaborating, especially after Magbanua refused a very generous deal. It seemed like someone else might be funding her defense to keep her quiet and protect the Adelsons. Eventually, the prosecutors filed a motion to remove those lawyers for lack of independence. And in this video, you'll see that argument play out in front of Judge James Hankinson. Here we go.
On order, balance session, James C. Hankinson presiding. Be seated, please, please. We're here in the state of Florida, Bishop Magbanua, 2016-3036. Let the record reflect the defendant present with her attorneys. We're here on the state's motion. You can be heard, Ms. Kaufman.
Yes, sir. May I call my first witness?
You may.
Your Honor, prior to proceeding with the hearing, is there a matter that we can address that the court may be of interest because this may actually alleviate the need to have a hearing in this matter?
You may be heard.
Thank you, Your Honor. And for the record, Tallahassee Christopher DeCosta on behalf of Catherine Magbanua.
Good morning, Your Honor.
I'm sorry, ma'am. Can you put the microphone in front of you? Would you like me to just step forward?
It'd be better if you did.
Thank you, John. And I'll just... Your Honor, the state filed their motion for conflict of interest inquiry back in February. And although we are of the position that they in no way in their motion and with the evidence that they've given to us up till last week have made us showing that there is any existence in of a conflict with me and Mr. DeCosta representing Ms. Magbanua, we at this point would have no objection to the court conducting an in-camera review to determine whether or not a conflict exists as it pertains to what the state has raised. This is actually something that they have specifically requested in their motion because this is what this entire hearing is going to boil down to. The state, I believe, in filing this motion and making these baseless allegations against not only my client, but Mr. DeCosta and myself, that we are somehow not acting within the Florida rules of ethics. As members of the bar, as officers of the court, we have consistently maintained that there's absolutely no conflict in this case. However, because we have nothing to hide, and this is something that we had to discuss with my client, that I did with yesterday while she was incarcerated, at this point, to avoid any hearing and any other misleading information being leaked to the jury, potential jury in this case through the media, to avoid wasting any further taxpayer dollars, at this point, we will concede to the state's request in the alternative that the court could conduct an in-camera hearing to determine whether a conflict exists.
And what would you propose would be discussed in this in-camera? I'm sorry, go.
So, Your Honor.
Did you?
No, it's okay.
Right.
So, Your Honor, what that would require is we would essentially be, if the court would allow that, we would be stipulating at this point that a third party is paying for Ms. Magbanua's fees, which in and of itself, the case law is absolutely clear from the 11th Circuit, that in and of itself, because that is actually specifically allowed for by the Florida bar rules, that if our client knows who it is and she consents to it, that is actually okay. But to avoid this hearing, because we have absolutely no problem revealing to the court in camera who it is that is paying for our fees, that we do it in that setting. The court reporter could be present. We would just request that it be sealed. And the reason we ask this, Judge, is because I do believe, and I did as much research on this as possible because I do not want to mislead the court in any assertions, that this would fall under attorney-client privilege. And the case law suggests that when there is a belief that this may fall into this category, the court must conduct an in-camera hearing anyway to determine that. And then, if the court were to order us to answer certain questions that we believe, the Florida rules specifically allow us to exhaust all appellate remedies to ensure that we are not doing anything that would violate our number one duty, which is to our client. So I think the safest way to approach this, which is actually what the state has suggested in this case, is to conduct an in-camera review, where the court would ask, what the state is asserting in this motion is whether or not the Adelsons have anything to do with our fees. That is what they're asserting in their motion, that they believe that if that's the situation, then there's a problem. We have asserted that there is no problem because that is not what is going on here. And in order to have the court make this determination, because that's the appropriate venue for this to take place, I think this would be the best way to satisfy both sides, Your Honor.
All right, so back to my question. I'm just trying to get the parameters of what you're suggesting.
Yes.
We would have an in-camera review, and you would indicate in there how your fees are being paid and the circumstances of that.
Yes, Your Honor.
What else would be discussed?
Well, Your Honor, at that point, because the state specifically lays out the steps that must be followed in their motion. If the first step, whether a third party is being paid. After Your Honor hears how this is taking place, the fee arrangement, if there is no conflict, there is no need to go any further. Because what the state was asking is if it was apparent to the court that there was a conflict, then they wanted the court to inquire of Ms. McBanwell whether she had consented to this, and whether, only if there's a conflict, if she waives that conflict. And then the court was going to take the state was asking the court to take a step further to then accept her waiver of this conflict. Our position is if you grant what we're requesting, we're not even going to get to go that far. Because when we have this in-camera hearing, it's going to be obvious to the court that there is absolutely no conflict with the situation that is here.
And what procedure would you propose?
Because, Your Honor, just in the best interest of our client, and I believe the law mandates this, an in-camera proceeding, which means the court reporter will be there, it will be private, it will be considered under seal, not privy to public viewing, because in that situation, we have to protect our client, because I do believe this falls under attorney-client privilege.
And who would take part?
Just as the state suggests, it would be with our client in the event that the court needs to proceed and ask her questions further, which we don't believe the court will need to do that. But essentially, we are willing at this point to let the court know how the fee arrangement is taking place, because despite the fact that we've asserted that there is no conflict, this, I think, will satisfy the state's request, since they're not taking our word for it, if the court were to view this information and make that determination.
But we would exclude the state?
Well, Your Honor, this is specifically what they're asking, is if that...
I've read what they're asking. I'm asking you what you're proposing. That's what
my
I'm trying.
first request, Your Honor, would be that they don't need to be privy to that information. Because with them there, it's still in violation of potentially an attorney-client communication. The court can then come out as a neutral party and explain to the state that you've reviewed it, you know what this information is, there's no conflict.
Right. Well, let me hear from them.
Judge, I'm comfortable with the procedure that the defense suggests, with the caveat that once the in-camera inquiry is conducted, if the court finds that there is no attorney-client privilege, I should then be able to be made aware of what was discussed. If there's a third party paying the fees and it's not a conflict of interest, I don't think that's privileged. I should be able to know whether it is or it isn't, who the third party is. But I'm comfortable with the initial procedure of Your Honor reviewing it. If there's a matter that's subject to attorney-client privilege, then I'm comfortable not finding out whatever that is. But anything that is outside of that, I think I should be made aware of.
I think the in-camera review is an appropriate step in this, and I actually contemplated that. But I guess my problem, and I'm just kind of thinking out loud so that y'all can address it, I don't know what the state knows, because, you know, we've had no presentation at this point in time. My concern is whether what, you know, I don't anticipate it would, but if what is presented to me is contradicted by evidence that they have, I'm trying to figure out how I would know that and how I would deal with that. That's my main concern with this.
Your Honor, at this point, I would say that I am completely confident that you would not even need to take that step further. I've had an opportunity because the state has provided to us, and even up till last Wednesday, they provided to us everything that they intend to present in this hearing. And nothing that they have would essentially impeach or contradict who is paying our legal fees at this moment.
And I don't doubt your word on it. I guess this is a fairly hotly contested matter, and I guess I feel like I need to be able to know that independently in some way, and I'm trying to figure out how I would do that before I launch into something. Do you have a suggestion?
Your Honor, I would suggest we proceed with the in-camera hearing. We present to Your Honor what it is that we have, and then Your Honor then make a decision if you would like to hear from the state if they have, because this is where I see where your concern is, Your Honor, that this is where it begins to get if us asserting privilege and them not allowed to be present, if that would then sort of muddy the waters of what information we could release to the state. So, but I think that would be a good starting point, Your Honor, and then as it proceeds, because I do believe it's not going to go further than that.
Okay. You want to be heard further, Ms. Kaplan?
No, sir. I mean, I think I trust that you'll know if you're in a posture where you don't have enough information to make a decision, then we can have whatever hearing is necessary for you to make it. I mean, I think we can cross that bridge when we come to it. I don't think you're going to make a decision that there's not a problem when there really is.
I think the in-camera review is probably good. And let me lay this out, and again, I'm laying it out for comment, not trying to announce an edict. We'll have an in-camera review. If I feel like there's any question about it, what I probably will do is ask the state to proffer what it is they believe they would show if we were to go to further into an evidentiary hearing. See if I feel like there is a contradiction there that needs to be aired out, and then we proceed from there.
Sounds good.
Is that agreeable to the defense?
Yes, Your Honor.
Ms. Kappelman?
Yes, sir. That's agreeable.
Okay. So y'all want to meet? We can meet in the jury room with court reporter, your client, and we'll have our comments there. Anything else the state wants to be heard on before that?
No, sir.
Okay. Want to give it 5 minutes and then we'll meet in? Yes, sir. All right. Okay.
Order is back in session. Be seated, please, sir.
All right, after the in-camera review, the court is comfortable that the payments for the attorney's fees in this case are being paid by a third party unrelated to the Adelson family, unless the state has some direct evidence to the contrary. I don't believe any further inquiry is needed or appropriate.
And will that third party be disclosed to the state?
No.
And the basis for that is attorney-client privilege, right?
I think the basis for that is there's no real reason to disclose that, and I think it's more a privacy concern for those other persons than any other basis.
Okay, Judge. Well, I mean, I would object to not being advised of the third party who's funding it. I don't think that is subject to privilege. I don't know the legal basis to protect the privacy of the third party. So I would ask that that be disclosed, but other than that, I don't have any further comments or don't care to put in any evidence or anything to that effect.
Good. I take that then you have no direct evidence that the payments are being made by someone connected with the Adelson family.
No, sir. I can't say that I have direct evidence of that.
All right. I have made the inquiry the state requested to determine whether a third party is paying, whether based upon that there is a potential conflict. And if there was a potential conflict, had the defendant waived that conflict. Based upon my review, there is not a potential conflict involved based upon payment. Therefore, I think the inquiry ends. To the extent the state's motion was for me to conduct such an inquiry, it has been done, so the state's motion was granted to that effect. To the extent further inquiry is sought, I deny the request for further inquiry. And frankly, I don't think the court should have any further involvement in attorney's fees other than if there was a potential conflict. Therefore, I deny your request to order disclosure. I suspect the defense would probably tell you who they're talking about should inquiry be made, but I'm not going to order that they do so.
Yes, sir.
All right, we'll be in recess. Oh, we need a case management, I'm sorry. What are we going to set for next?
I would request that she be set for trial along with the similarly situated with the co-defendant, who I think is in January, so somewhere thereabouts.
Do you have the date we said co-defendant?
Are we looking for that trial date?
Yes.
Trial is on January 22nd
Yes,
with
February 2nd.
So these are not consolidated cases at this
They
point in
currently
time?
are not, Judge, but I would like it set that same time frame or as close thereto as Your Honor will allow.
So are you going to be moving to consolidate them?
I am certainly considering that, Judge.
If I can inquire through the court whether the state has realized the Bruton issues in the case.
I beg your pardon? I'm sorry?
The Bruton issues that are present in the case. I believe that this is a case that would have to go separate. Mr. Garcia's case being a death penalty case.
Right.
And
I'm not here to make that determination. There's no motion to consolidate before me. Certainly, I understand the issues you raised. I think there are a number of issues. But anyway, aside from whether they're consolidated or not, what's the defense position on January 22nd trial date?
I think it's possible. We, as much as a state, want to get forward to trial, to have a jury in that box, to have them hear the facts of the case. I can give Your Honor an update of where we are with our discovery. I don't lay this out because we're trying to buy time, trying to get continuances, but just so the court knows. We have a total of 136 witnesses. We've deposed 39 of them. In February, I asked the state for available dates when we could take a large amount of these depots. I was given a sprinkling of dates, individual days, nothing solid where we could take a lot of depots, but essentially I was given the week around Memorial Day. We came in, we took 40 depots. In June, I asked for additional weeks, and I said to the state, we've got pretty much every week available during the course of 2017, except for certain dates when we're in different trials. The response I've got right now, and I know the state may have other dates because there's some other issues, but they gave me a week in the end of October. We have several more rounds of depots. We know we have a solid round of depots up here in Tallahassee. We have to go to South Florida for a solid round of depots. We have to go to wherever Luis Rivera is being housed. We have a witness in Oregon. We have a witness in Gainesville. And the potential of 2 witnesses that are outside of the country, I don't know if we would have to depose Mr. Markel's parents. I don't know if the state is calling them just for identification. Possibly it's something that we can work out. We do have a few other issues. There is an undercover video where an FBI agent is wearing a camera and they're in Dolce Vita and they're in a condo building on the South Beach. We've asked the state for the original data so that we can look at it on our system and have our experts review it. The FBI in response has said, because there's proprietary software on there, we can only get their enhanced copy. When I hear enhanced, I'm thinking changed. I'm thinking altered. So the only thing that we've been given are these enhanced copies, and the only way they'll allow us to see it is up here on their systems. Now, I'm not trying to point a finger at the FBI of wrongdoing, but we need to have the original data so that we can view it. Also working in federal court, I've received many of these before, so many defense counsel in the federal bar already have whatever it is that they believe is proprietary software. I believe that it's going to be no different than any of the hawk materials that we receive in cases. So this FBI is trying to hide behind that instead of giving us the original. We gave them a 4 terabyte drive back in January, I believe. We're still yet to receive it. We also have reached out to the state, and this goes over the past month since we took that last round of depots, to depose a handful, and the state can correct me if I'm wrong, about 20 FBI agents. We don't know where they're located. We don't know where in the state they're located. In response, and in my initial email to the state, I go, Department of Justice is probably going to ask for 2 notices, which on a state deposition case is nearly impossible because I don't know what I don't know. And the last thing I want is a deposition where a witness is saying, I'm only going to answer questions that's in the TUI notice. TUI works very well in federal court, but federal court doesn't anticipate depositions. I had reached out to Ms. Kappelman. I had then gotten an email from AUSA located up here. I spelled all this out and explained it. And essentially what it came down to, and there is case law in the Florida Supreme Court that talks about it, that if the state wants to put any of those agents up on the stand, that I should be able to have an unfettered deposition where I can ask, what was everything you did in the case to find out anything inculpatory or exculpatory? Given the state's motion, and not to go on to the other topic, but the the motion that they just filed with the fees, they're trying to avoid any collateral attacks later on in time. I believe the state wants me to make sure that I ask those agents or anybody that testifies every single question. So I don't doubt the state's helping out with this. I had asked and I said, I don't believe that it's in my position to have to talk to a federal AUSA about setting depositions. I think it's something between the state and the feds to figure out who we're going to bring in, how are we going to bring them in. And I also question whether there was even a TUI notice when Agent Sanford testified before the grand jury, because if it's good for the goose, it should be good for the gander. But at the end of the day, we just want to take the depots that we need to take. We had set up a meeting with Mr. Newell from the state attorney's office to view all of the iCloud messages. Going on to a different topic now. Charlie Adelson had a iCloud messages, and it spans over a couple of years. We set up an appointment to sit down and view that. The reason why the state won't give it over is they're claiming that there's HIPAA material in there. There's some names of patients. So the only way we can view it is going down the hall to Mr. Newell's office. Unfortunately, when we went in there, and I'm not saying that Mr. Newell was doing anything, but the information was not in a manner that we could view. It was scattered. It wasn't in its original form. So we have to set up another meeting to come up. And based on the amount of information, we think that it would probably take about 2 full days of whoever goes in there to view it, to be able to get through all the data. I mean, it's years worth of emails and text messages. The last thing we have is a surveillance. The state gave us 8 months worth of surveillance, and they gave it to us a while back. And again, just letting Your Honor know of everything that needs to be done on this. There's 8 months of surveillance, roughly 5,760 hours. If I were to work a 100-hour week every single week, and I don't think I would be able to keep up stamina-wise, it would take 57.6 weeks to get through it. Thankfully, we can speed it up a little, not a lot. And of course, there's multiple attorneys, so we can both break it up, but it's still something that we know would take months literally looking at the camera. We don't want to not look at something on the case. So I give that as an update to the court of what we've done since the last time in court. We've gotten through a good amount of it. We've deposed pretty much every Tallahassee Police Department officer. State was great. All the witnesses came in. There was only one witness that didn't come in. There was a service problem with. He's out in Oregon now, and we'll be able to take it. So again, just giving Your Honor an update. The defense's position is possibly another date sometime in the near future to report back to the court where we're at with an idea of a January trial date. It's just, that's why I answered the original question with possible, just because I don't know. If I'm only getting dates in October for depot, it may be difficult because I know after the agents, that we've got to go to all these other places, and the state, I would imagine during November and December, have plans for the holidays, and we may be very tight on time then.
Well, understanding that there are several potential issues, one of which would be whether we do a joint trial or not, I'm going to go ahead and set it for that date that the state has requested. I understand that these things aren't etched in stone, and the state has some obligation to make things work if they want it to go then, and we'll work from there. At least we have a date to shoot towards. So we'll set it for January 22nd. Pre-trial will be January 3rd, 10:30, and the final pre-trial will be January 18th at 1:30. Those are all 2018 dates, which be hard for me to get used to, but anyway, that's
It's a year as well.
time passes on. All right, anything else we need to take up?
No, Your Honor, not from the
All
state.
right, we'll be in recess.
Thank you.